Welcome to Who's Point. I want to talk about today the return of his brief by Mr. David Perry, Queen's Counsel of London. As you may have read in the news, he was engaged by the Hong Kong government to come to Hong Kong to prosecute a criminal case, I believe in a district court in Hong Kong, that starts next month. Quite an important long case. And the case is about the question of the public order ordinance, which restricts the right of assembly when it becomes an unlawful assembly. So this is a subject which is very relevant to everybody in Hong Kong when it comes to one's freedom of assembly. And what you have is a law which we adopted during colonial days from British legislation called the Public Order Act. And that is still current in England, and it's been used to curtail certain activities by the Extinction Rebellion group, for example, in England, trying to seize squares and needing permission to protest at certain agreed sites beforehand. Very similar in operation to the Hong Kong Public Ordinance and how it's applied by the Hong Kong police. It's very much the same. I was there a few months ago in England and saw how the Extinction Rebellion were trying to take over public squares and junctions to have their mass protests. But again, it's the same legal framework we're dealing with here. It's the Public Order Ordinance taken from the Public Order Act, which is current in England and current in Hong Kong. And what Mr. Perry is asked to do is that in his role as Chief Prosecutor for the Hong Kong government to take a lead in the court's discussion on where the equilibrium should lie between freedom of assembly on one hand, which we all know even under international covenant prescription is not absolute, right? And on the other hand, what amounts to illegal assembly and whether there is a calibration of these two conflicting principles by judicial interpretation. And that is very important for somebody with the experience of Mr. Perry to come and help the court. He's not here, and a lot of you who are barristers know this. A barrister, when he's engaged to prosecute a crime, his duty is not to secure a conviction at all costs. No. His job is to fulfill his duty to the administration of justice, which is to present all the evidence against the accused fairly and properly, and to make sure that justice is well served. He's not there to get a conviction at any cost. And in this case, he was admitted by the court in Hong Kong for the purpose, as stated, of assisting in this constitutional question as to where the jurisprudence of the assembly law in terms of the illegal assembly and freedom of assembly issues, how the court should approach it, and to assist the court, to give it a good discourse by the courts, and the matter may be examined by a higher court later, but it is there to fortify the jurisprudence on the subject, so that not only does the law of Hong Kong, it's not just this one case, this case is a landmark case, which is going to set the tune for illegal assembly under the constitutional framework in Hong Kong. And it also benefits, as the judge in his admission said, the profession, the Hong Kong legal profession will benefit from his experience and input and leadership in this case. Now, having said that, you would have thought, well, what's the fuss all about? Well, let me give you a simple sequence of events. I think, and I'm quite sure that he was approached at least 6 months, if not longer ago, by the Hong Kong government. He has worked for the Hong Kong government before. He's been admitted to Hong Kong to lead in important criminal cases before, and has always been seen to be a fair, able, and principled prosecutor, earning the respect of many, not just in the legal community, but also in society at large in the cases that he has handled in Hong Kong. Now, the government asked him, and the first thing is obviously to ask him whether his dates are suitable. Right? So either the dates are set according to his diary, or the dates meet the availability of his diary. So the first question is always, is he available? So the answer is yes, because he took the case. Now, having his clerk indicate that he's available for those dates, he must also indicate, of course, at the same time, that he's available to be leader of the team to give advice, right? From the moment he accepts instructions as to how this case is going to be conducted from the prosecution side in terms of what disclosure to make to the defense, all sorts of these pre-trial procedures that he has to be in charge of. Now, we have what's in the profession called the cap rank principle, the taxi cap rank principle. What does that mean? It simply means this, that we can't pick and choose our clients. That once we indicate to a client who comes knocking on our door that we are available on the dates that he wants he or she to appear in the case, then we must take on the case regardless. So it's like when you open the door to a taxi which is vacant, the driver cannot reject the fare. But having said that, when it comes to a representation by a barrister in a case, there's also a second step apart from his availability. The first one is called the taxi rank principle, all right? So he's available, so he can do the case. The second is obviously he has to go for what we call an audit check in terms of, is there a conflict of interest in the case? Certain major issues arise. Number one, although you're available, are you the right expert for this case? Is this case a criminal case, or is it a divorce case, or is it an inheritance case, or is it an equity case for which, although the client may think the world of a barrister in his advocacy, may not be his particular topic. It may not be the area that he's expert in, then he cannot take the case because he would be completely at sea in that particular area of the law. That's one example. The other example is that whether he has a conflict in terms of having acted for a witness or the other side, or a connection with the judge, all these things which you can normally think of are there as to whether there's a conflict of interest. But there's another aspect, the chapter that guides one's behavior at the bar when deciding whether one can accept the case after checking that you're available for the dates required, is the fact that whether it will cause you embarrassment or conflict of interest. Now, I've explained what conflict of interest is. Embarrassment, what does that mean? Well, if the circumstances of the case will cause the barrister embarrassment in the discharge of his duties, right? When, for example, a client wishes him to lie on his behalf, right? For example, it causes him embarrassment, or in the fact that he may not be able to maintain his professional independence. Right? Now, there would therefore be very high standards for the barrister to audit once he's seen the papers, because he must always remember that the bar is a very noble profession. It's not just a professional organization of lawyers. It is a very noble profession in England where one is expected to act like a gentleman at the bar. So the standards are very high. You can't have a conflict of interest. You can't even be embarrassed in the discharge of your duties. Your integrity must be beyond reproach in the case, in accepting the case. But having accepted the case, then you must defend and stand for your client's interests, especially in a criminal case, without fear or favor from any third quarter. That is the cardinal principle. Once you've accepted the case, the worst thing is to let a third party exert pressure on you for you to not represent your client, for you to have your discretion in protecting your client's interests undermined in any way. That is a complete taboo by both the standards of the British bar and the Hong Kong bar. And as I've said, once he has done this check, conflict and embarrassment check, and of course a subject I suppose very dear to certain barristers, if not all, a subject very dear to all barristers' interest is obviously that the fees that you quoted are accepted by your client. And once that is all happily resolved, you accept the brief. Right? Barristers cannot appear for a client until he's accepted a brief from his instructing solicitors, which sets out the whole circumstance of the case and the terms of your engagement. And once he accepts the brief, and I said in the case of Mr. Perry, it must be well over 6 months ago, right? He accepted the brief, all these checks have been passed. He is now in the saddle, so to speak. Right? And he is in charge of the prosecution team for the Hong Kong government. He's giving advice, and he's giving them instructions how to do all the pre-trial procedural work before his arrival in Hong Kong. Then comes the third step, which is what? Well, he can't just walk into Hong Kong and practice. It's like all jurisdictions, they have to protect their own legal profession. So the only exception in Hong Kong to allow outside counsel from coming into Hong Kong to do a case is when the case is a case because of its public importance, not just a normal criminal case going after a certain group of defendants for criminal behavior, but where the case is of public importance in the sense that the legal principles involved, that there will be an argument as to important legal issues, and in this case also constitutional issues, which requires experts from a place like England, which is the origin of the common law, to come with his wealth of experience and knowledge to come and assist the court. And it is precisely for this very reason that Mr. Perry was allowed to be admitted to Hong Kong. And I remind everybody, just to do this case, only this one case on public order, on the section that deals with unlawful assembly under the Public Order Ordinance, which, as I've said, is taken from the Public Order Act in England, which are still current legislation in England and in Hong Kong, and both police forces act under the same. Now, having said that, what is very amazing is this permission by the High Court in Hong Kong, by Mr. Justice Poon, to allow him to come into the case was given on the 12th of January this year. Right? So all the papers are put in last year. There was argument with the bar, voicing concerns whether there are local talent to do it for this case. And when the court found that no, this is where we need imported talent for this case, he granted the order on the 12th of January. So everything went smoothly. So he's expected to arrive after that order is given to take over, actually also complying with quarantine requests in Hong Kong, and to give his instructions as to how the case is prepared so he can appear in court next month. The trial is to start on the 16th of February, right, for many days in the district court. What was astonishing is that 5 days after the order by the High Court in Hong Kong to admit him to practice in Hong Kong, months after he's been asked to take on the case and have taken on the case, 5 days later, on the 17th of January, the Foreign Secretary, 5 days after his admission, the British Foreign Secretary, Mr. Ryab, gave an interview on Sky TV in England. And when he was asked about Mr. Perry's acceptance to prosecute this case in Hong Kong, he immediately launched into a scathing attack on the integrity, the professional mores of Mr. Perry in accepting the case. He said that this was entirely against all conscience to accept this case. What are the reasons? Well, the first one, he said, Mr. Webb, was that he is acting on the behest of the Beijing authorities. On the behest of the Beijing authorities. To do what? To apply the national security legislation that suppresses the freedom of the people of Hong Kong. Really? Where does Beijing fit into this? They don't engage British counsel. It's the Hong Kong government that engaged Mr. Perry, number one. Number two, the most important point, it's got nothing to do with the national security legislation. This is public order, not national security legislation, not treason, sedition, subversion, disclosing state secrets. This is public order to keep the Queen's peace. This is the similar legislation. Mr. Rayab is a lawyer himself. Did he not read his brief before he went on Sky TV? What are you talking about? It's got nothing to do with national security. He's only admitted to do one case to deal with that section of the Public Order Ordinance taken from the Public Order Act in England. What's your complaint? Incredible that a person of such high office could be so reckless in such an attack on a professional who enjoys huge respect in both the English legal circle and the Hong Kong legal circles. Appalling. And then he goes on. He then said that, furthermore, Mr. Rayab continues with his attack, and he says, quote, "There's no doubt in my mind that under the Bar Code of Ethics, a case like this could be resisted." So he's saying that under the British Bar Code, Mr. Perry should not have taken on the case. Is that right? Which part of the code says that? He's accepted the case months ago, clear in his mind that there's no conflict or embarrassment that would be caused by him prosecuting for the Hong Kong government in a case, as the Hong Kong High Court says, is very important for the development of Hong Kong's constitutional jurisprudence and the Public Order Ordinance. And the court says it is of great import to the local profession to be able to work with Mr. Perry and learn from his experience. These are no idle comments. This is a case where the Bar Association objected to his coming because they said local talents available. The importance, the constitutional importance of this case is clear if you simply read the judgment. But do you think Mr. Rayab has read it? And also that having satisfied himself that there are no qualms either in his conscience or professional standards, that he can accept this case comfortably and competently, pressure was brought to bear by Mr. Rayab on the pressure was brought to bear by Mr. Rayab on the 17th of January. And lo and behold, immediately after that, the 17th was a Sunday, on the 18th or the 19th, Monday or Tuesday of that January, he returned his brief to the Hong Kong government, which then had to give out a press statement on the 20th to explain why Mr. Perry is no longer coming to Hong Kong to do the case. Right? And now they have to find somebody else in a hurry to take his place. The trial is to start next month. Now, the reasons given, according to the Hong Kong government, is the pressure that Mr. Perry was made, and then there was some reference to COVID-19 quarantines. I think that is just an excuse, if you ask me. Or this is well prepared as to how it can fit in with the quarantine regulations. But in any event, the point is, this is naked, stark naked interference by a person in political office on a very respected professional Queen's Counsel to help with the administration of justice in Hong Kong. And even any person who just look at what the case is about knows it's got nothing to do with national security. Now, was Mr. Perry even asked to explain by Mr. Rayab? No. In fact, what worries me and what saddens me is Mr. Perry is so beaten by this pressure that he can't even be prepared to explain the obvious, off-track thinking that this is to do with national security. Right? Whether he would do a national security legislation is another argument, but this case is about Public Order Act and the Public Order Ordinance in Hong Kong. Right? Why does he not explain that? Because he's been browbeaten, he's been giving up so much pressure that basically it's a completely undeserving attack on his person, not just his professional integrity, but talking about being mercenary against his conscience from a foreign secretary of Her Majesty's government against one of Her Majesty's councils should not be lightly made. Really, with respect, Mr. Rayab, please, at least read your papers. Don't listen to just one-sided account of what's happening. At least get the facts right if you must condemn a person in a leading member of the British legal community to such an indictment, to such a sin of giving Beijing good PR. That's what it's about, isn't it, Mr. Rayab? It's about giving Beijing good PR. You want your administration to get the good PR, but that's not the way to go about it. And also the same threat by Mr. Rayab in his 6-monthly report about talking to the Lord Chancellor to try to discourage British judges from sitting in the Court of Final Appeal in Hong Kong. Again, that's stark naked interference with the independence of the judiciary. Don't you think these judges, these senior judges of the land, will know whether it is conscionable and proper for them to come and sit in the Court of Final Appeal of Hong Kong? You question their judgment, their experience, and yet after they've agreed and that they have sat and find that things are not what you say it is, and they do contribute to the jurisprudence of Hong Kong, now there's such naked and unreserved political maneuver to stop them from coming? Does that contribute to the rule of law in either Hong Kong or in the United Kingdom? As a lawyer yourself, Mr. Rayab, don't you think you should reflect upon this? It is therefore important that the Hong Kong government must complain to the British Bar Council over this case of the return of the brief due to unwarranted political pressure from the Foreign Secretary on one of Her Majesty's council in England. I think that this complaint must be made, and the Bar Council should look into this, and then we can all have an open and rational debate to see whether this is an interference in the rule of law or whether this is a championing by the Foreign Secretary in how the freedoms and rights of people in Hong Kong is best protected. Thank you.